Welcome to the bunker. Hey everyone, welcome back to the Colonel Channel. I'm your self-proclaimed commander, Lieutenant Colonel Lee Roger Wolfgram, coming to you live from the Wolfgram Worldwide Headquarters here in downtown Minneapolis, where I am a practicing criminal defense attorney. I'm in court most days. I'm in court after this. So I bring to you my own personal experience, and I've reviewed a lot of evidence for many, many cases. And there's something that I wanted to bring up, and I think that P. Diddy's case really illustrates this well. And so here's my question. Do you believe that a person is presumed innocent until proven guilty by a jury of their peers? And the reason why I bring up this question is because this is about the most horrific allegations I think that there is currently in the news medium, news cycle today. And I am, as a criminal defense attorney, very, very interested in the right for someone to be able to post bond. Because my belief is that if you are really innocent until proven guilty, then it isn't about the volume of evidence that someone may have against you. That merely means that the state may have a good case. But really what bail is about, it's about recognizing that you're innocent until proven guilty, and it's about allowing that presumption to carry the day and you to be able to be released under conditions that A, make sure that you're going to return to court and face the charges, and B, make sure that the public is safe. And with that said, let's jump in because there's some hard questions that we're going to have here.
Man, Diddy's world is crashing down hard. The lawsuits, they're coming at him like a tidal wave, piling up faster than anyone can count. And now, he's stuck in jail with no bail, facing the kind of heat that even his money can't put out.
And so this is the new development, and the reason I bring this up is because there's a new judge assigned to his case, and the new judge can actually reconsider the issues of bond or release. And so his legal team, P. Diddy's legal team, is bringing this up to the judge. They've brought it to the Court of Appeals, and then they've asked the Court of Appeals, wait a minute, let's just let the new judge take a whack at this first before we appeal it. And defense brings up some very good points, but also in the beginning, as I say, and I am a criminal defense attorney, Mr. Combs, regardless of the allegations at this moment in time, according to our Constitution and our legal system, is presumed to be innocent right now. Let's watch.
Sean Combs isn't just fighting for his freedom. He's pulling out all the stops to get out of jail before his trial even begins. The hip-hop mogul, who's facing serious ST and racketeering charges, is making his third attempt at bail after 2 hard denials from the courts.
Now, the reason why I put this screen up is because as I said before, I am a criminal defense lawyer. Mr. Combs and his legal team have full confidence in the facts, their legal defenses, and the integrity of the judicial process. In court, the truth will prevail that Mr. Combs has never sexually assaulted anyone, adult or minor, man or woman, and he enjoys the presumption of innocence. With that said, now let's just jump into the evidence. Let's jump into what's going on.
P. Diddy makes a third attempt to be released on bail, and this time it could actually happen. A new U.S. District Court judge has been appointed to the case, and now it's going to be up to him whether Diddy is released.
In a recent filing with the Second Circuit Court of Appeals, where he is appealing this bail issue after, again, he was denied by 2 judges pretrial release, he says, and this is an interesting argument, Mike Jeffries, the former head of Abercrombie & Fitch, who was just arrested for sex trafficking pursuant to federal charges in New York, why does he get bail?
Why does he get bail? This is a really interesting point, right? Because these are pretty similarly situated predatory offenders of minors if you consider the allegations to be truthful, but really the allegations only have met the probable cause level here. So it's probably true, but that isn't proven guilty.
Let out in bail. That's an important point. In fact, in Combs' filing, he states, Mr. Combs is entitled to release, which has been granted to many similarly situated defendants, including just yesterday, a CEO accused of sex trafficking dozens of young men, including through witness intimidation. the government's request for detention is not based on any genuine risk of danger or obstruction. It is based on a desire to punish Mr. Combs.
And it can't be that. It can't be about punishment. It has to be about whether or not he is presumed to be innocent or guilty. And we know that he's presumed to be innocent. So somewhere there is a set of circumstances where both the fact that he will return to court to stand before the jury and the public is safe. There are ways to do that. And, you know, on a regular basis, I make these arguments with judges is that, you know, setting bail high only assures that they will never get out. So that's problematic for some people because they've got a high bail, they can never get out. And the other reason is to assure that there's public safety. Well, the judge has a myriad of tools that they can use to assure public safety. They can do house arrest. They can do geo-tracking, GPS tracking. They can create whatever circumstances to kind of make a little jail, but at least it's not in custody in a jail facility where he should be presumed innocent. And so let's jump in, see what else is going on.
Alongside the property pledge, Diddy's legal team has offered further assurances, including GPS monitoring and travel restrictions to only Florida, New York, and New Jersey. His private jet, which he reportedly intends to sell, would remain grounded as an additional compliance measure.
Okay, so if you're onto this channel, you know that I'm a pilot, and let me tell you something about this whole airplane thing and him taking off and running away. That's all a bunch of bullshit. Look, they have to get clearance from the tower to take off. And there's not a pilot in this entire country that's qualified to fly that aircraft that is going to wreck their career because it takes a long time and a lot of money to get to be able to fly those things. They're not going to just take off without clearance from the tower. It's not going to happen. It's an impossibility. So as long as they have the aircraft at a place where there is a control facility, it's not something you're going to pull out of the hangar in the middle of the night and take off. That's all that's required, and it wouldn't take off anyway.
To address concerns tied to the allegations, the team also proposed a significant restriction on who can visit Diddy's residence. Only immediate family, caretakers, and specific non-co-defendant friends would be permitted entry, with strict logs of any visitors. This restriction reflects efforts to counter prosecution claims that Diddy could potentially pose a risk of continuing the behaviors alleged in the case if released on bail. Despite these extensive concessions, prosecutors remained firm in their stance, arguing that Diddy's release could still pose a danger and that his resources might facilitate a potential flight risk if he were released prior to trial.
This would testify at...
Okay, so before we get into this, so here's the point. So they say, well, he's got so many resources that he could just use his resources and he could abscond. He could leave the country. He could escape jurisdiction. And the public's not safe. Well, come on, Judge, use your head. You can do something that whatever your concern is about public safety, make a rule about that. It doesn't have to be in the jail. If you want to have all of his calls go through a switchboard so he can't threaten anybody, hey, you're the judge. Make that the order. If it is, he can't leave the house at all. Hey, it's your order, Judge. And if it's about these, well, how does this occur? He does have the resources, so the government can't have it both ways. Oh, he has the resources so he could just abscond, when actually what he's doing is he's putting up his resources to create the conditions for the judge to be able to do the two things the judge needs to do: assure his return to court and to make sure that the public is safe.
To the events surrounding kidnapping and break-in, the latter of which is corroborated by police reports and other records. So they have him for kidnapping at gunpoint. And all...
Okay, so here is one of the unique characters of this case versus the other one where there is a predatory offender that was released, and that is the allegations of violence, which do create a new ripple to this. But again, the allegations of violence or any allegation is still just an allegation, and just because it's put on a police report or just because it's put on some legal document doesn't make it a fact. And if there are public safety concerns about violence, again, come on, think about this. Easy stuff.
So they say approximately 2 weeks later, the defendant's co-conspirators set fire to individual one's vehicle by slicing open the car's convertible top and dropping a Molotov cocktail inside the interior. Now, this is making reference to a rapper named Kid Cudi who was interested in dating Kathy Ventura. Diddy found out, and Diddy had people blow up his car. So they're referring to that as a reason why Diddy should not get bail. They're saying that he is violent and he has other people that are willing to commit violent acts to protect him.
Okay, so I did raise this in an earlier video. This is kind of a, if these allegations are true, this is like the mafia. I mean, if you listen to this, like, okay, so someone was going to date his girlfriend. It sounds like a Casino with Robert De Niro and blows up the car. This is organized crime, and this is one of the things that I am also watching very carefully, because I believe that this is set up very much just like the mafia. It's just a different word for it. But these are thugs that accompany him, that carry out his orders for violence. And it's all sort of this secret organization that if you cross, you could be looking at life-threatening kind of stuff. So that's why this has that different character. But again, these are just allegations, and even if there is some evidence, they haven't been proven, and he is entitled to release conditions that address that concern about public safety. Let's go on.
So his lawyers start by saying the government failed to present clear and convincing evidence below that this is the rare case justifying pretrial detention. It offered no legitimate reason why the proposed release conditions would be insufficient to mitigate the risks it claims exist.
True. All you got to do, Judge, is if there's something in this proposal that doesn't quite meet it, and I think these are pretty fair restrictions that they could be added to if you need a little bit more assurance. But come on, again, these are judges. These are learned legal minds. Figure it out.
Although Mr. Combs' conduct on the video is indefensible, he's apologized for that conduct, which must be evaluated in the unique context of the toxic romantic relationship in which it arose. But regardless, that conduct and that relationship are long in the past. The conduct in the video is not evidence that Mr. Combs will engage in any future violence.
Very true fact. So they're talking about the Cassie Ventura tape, and I think they're going to show it here. But, okay, so that does say that there has been violent history. How long ago was the violent history? Is that the only violent history? And does it prove anything when it comes to future tendencies to violence?
Now, the government would say that she was actually escaping one of these freak-offs, which is a key component of the indictment. And they've also said that these freak-offs extended much past 2016, that it was happening also, I believe, in 2024. But despite that, Combs' lawyers are saying that the conditions that we're proposing in our bail package, such as no contact with any women other than family members and his lawyers, that negates that risk that he would be a danger to women. And when it comes to the allegation that Combs was reaching out to witnesses improperly, well, they're saying, you know what, even the government says, yeah, Combs was reaching out to one of the witnesses, but this was months before the lawsuit was filed, or that specific lawsuit was filed. His lawyers say his contacts were in no way obstructive. And the fact that the witness and Mr. Combs had 128 phone contacts, that doesn't prove anything. And they also say, quote, of course the government has the actual communications and would describe them for the court if they truly revealed obstruction, but for the third time, it has failed to describe them because they reveal nothing of the sort.
Interesting point here. So again, we're just going off the allegations, the complaint. We haven't seen, or the indictment, we haven't seen the evidence here. So there's evidence out there, and if the government has that evidence and that helps them make their point, well, they haven't done it. Why not?
That lawyer knows that Diddy doesn't have a Chinaman's chance of getting out, but he will just file all kinds of motions and call for hearings. He knows he's not going to get out on bond. You know, you got a better chance of Jesus popping in here with us right now than that happening. He's not getting out on bond. They did an interlocutory appeal, which means you're appealing something before a ruling is final.
Combs' team doubles down that their bail package, it's sufficient. We've mentioned this before on Sidebar. Home confinement, 24/7 monitoring by a private security team, $50 million bail, no internet, no phone use, limited visitors. The visitor logs would be provided to the court. And this part's interesting because you see the government had previously argued that it's not fair to have a two-tier justice system where Combs would be permitted to stay free on sex trafficking and racketeering charges because he has the financial resources to turn his home into a private prison, whereas you have a defendant of lesser means who couldn't put forward that package, and therefore they would be denied bail, they would be locked up while waiting trial. That's not fair.
And that's true. Bail should be adjusted based upon the resources of the person that is being considered for release. A person that doesn't have that kind of money, but maybe they have a house or maybe they have something else that is going to, if you attach that, if there's enough bail to put a major asset up like that, again, that is going to make it likely that that person, even with less money, doesn't have millions of dollars. But if their house is on the line, or you've pretty much taken their resources so that they can't use them to evade the law, well, then the bail should be less for that individual. Bail is an individual thing. So in this case, if he has the resources to address the concerns of the court, he should be afforded release. If a person with less resources puts the same percentage or like the same way conditions together with the court, they should be released without millions of dollars of bail.
Combs' team says, well, wait a second. We're offering this package and these conditions because Combs is wealthy. The government said he's a risk of flight. He's a danger because he has this money and resources. So the reason that this bail package looks like this, the reason it's so expensive, the reason he's essentially turning his home into a prison is because this would be the only way to ensure all of the concerns the government has. That's why it looks like this. The government, they say, can't have it both ways. It can't use Mr. Combs' wealth as both a detention sword and shield.
Okay, so we're kind of talking about this quite a bit. I think you see my point. So again, I come back to you, and if we really believe in our system where a person is presumed innocent, do you see my point? That presumption of innocence is a presumption of innocence because they have not been proven guilty by a jury of their peers. And so somewhere in between, the conditions can be set to assure that they return to court and that they are not a danger to the public. That's my argument on every single case I have when I have someone that is in custody. And sometimes the judges just look at this probable cause and they think it's only way to have public safety is to order them to remain in custody. And that brings on a myriad of other challenges for the defense. And that's not fair either.
So this idea of what really is the government's evidence about obstruction. And then Combs' lawyers say the government can't even argue that he was engaging in obstruction by contacting grand jury witnesses. Quote, one witness contacted Mr. Combs, not the other way around. The government fails to address this, nor does it respond to Mr. Combs' argument that the bare fact that two individuals spoke is not evidence of obstruction because the government cannot prove Mr. Combs intended to tamper with these witnesses. He did not. The government's silence underscores why the district court erred in relying on the government's unfounded assertions. So Combs' lawyers are also saying, if you look at the past cases, you need to have substantial evidence of obstruction in order to justify pretrial detention. And then,
okay, so there is case law on this and you heard what they said. It is the extraordinary case where there would be justification for pretrial detention. And so let's talk about that.
they say the case that the government is relying on, saying you only need to show one episode of witness tampering to justify detention, Combs' lawyers say no. That case they're relying on was about a decision to revoke bail once it was granted, not...
Okay, very important point, right? So when you initially set bail is one thing. You're telling the defendant, look, you comply with these conditions or I'm going to take you into custody because you failed to comply with those conditions. When you're talking about the possibility of revoking that, it's because some violation has occurred. And of course, that means you don't follow the judge's order already by the time you're coming in and asking. That's what the government is trying to use and say, this is the standard. And what Combs' lawyers are saying, no, that's not the standard. This is the initial setting of conditions of release. This isn't after someone has demonstrated they're not going to follow the court's order, and then they cite a case that is about just that. Someone who had been released, who was revoked, and now is asking for release again after revocation. Completely different case.
Ordering detention at the start of the case. The defense says the bar to have bail revoked is much lower. You don't need as much evidence to justify that. It's not clear and convincing. That's not the standard as we have with Combs' issue here. So that's a really interesting argument. And despite that, Combs' lawyers are saying in that case that the prosecutors are relying on, the government in that case, they had 3 days of hearings, they had 12 witnesses, they had all this proof to show that the defendant had engaged in witness tampering. Here, there was no hearing, there was no witnesses. They're basically making the argument that the court just took the government's word for it, that Combs was obstructing. And Combs' lawyers say the government has no actual evidence, just the allegations in the indictment. And they say that's a problem. You can't rely on the indictment.
True. So where is all this evidence, right? They've executed all of these search warrants. There must be all kinds of evidence that's available. Why isn't the government presenting it? And again, this is just, in my view, this is just lazy. So you use one case to try to pull the wool over the court's eyes, saying, oh, look, in that case, it was this standard. Well, it's a mischaracterization of where this case is compared to the one you're trying to use. This is the initial setting, right? So keep in mind, there is the appeal that has now been, essentially, the Court of Appeals will say, wait a minute, we're going to have the other judge look at it. These are the arguments, and I think that these are really persuasive arguments. A, that similarly situated people with the same sort of violent predatory tendencies about the public, they were released on conditions, and it does, and now we're talking about evidence that isn't been presented at all, and we're still trying to keep him in custody. So that is unfair. And here's what the problem is for the defense counsel, right? So if a defendant is out, they can review the evidence. You can have informed discussions, but when these federal cases come, we're talking terabytes of evidence. The last federal case I had was terabytes. I had to hire a company to sort through the evidence in order to find the stuff that I could basically spot the issues on. So it's not something where you're going to sit in your prison cell and you're going to be able to go through terabytes of information and then be able to take notes and have a meaningful preparation for your defense. On the other hand, if you're able to look at those, take those notes, that is greatly going to assist in your defense. So you're not handicapped just by the communication between defense counsel, and the lawyer can't be there the whole time that the client is going through terabytes of information. That has to be something that the client does on their own, defense counsel does on their own. Then they kind of put their heads together. That's how this should be done.
They say, quote, an indictment at most reflects a grand jury's finding of probable cause that the defendant committed a specific offense. It does not reflect any finding of clear and convincing evidence, which is the standard required to justify detention. And here it is unclear whether the grand jury ever even found probable cause to believe that Mr. Combs committed any witness tampering. There's no obstruction count. That's true. He's not charged directly with obstruction. What they're arguing is that, yes, the grand jury, they found probable cause of racketeering conspiracy, and yes, obstruction is one of the underlying listed acts of that charge, but there were a lot more that were listed. And the grand jury didn't necessarily find that obstruction was committed. They could have said there's probable cause of racketeering because of sex trafficking, because of bribery, because of arson, because of kidnapping, maybe not necessarily obstruction. They didn't say that. So these are all these other underlying acts that the grand jury could have relied on to say that this is a racketeering conspiracy.
Okay, so now the concern is the safety too. So this is a secondary concern, and it is, in my view, if the government can't protect you, then the government almost has a greater obligation to give you pretrial release because they don't provide a safe environment. And so there have been investigations now that have been started into this facility in Brooklyn that P. Diddy is currently being held at. But the real problem is that he is going to have a much different experience in prison where he is at now than other prisoners just because of the allegations, because there's a whole thing about being a child molester. And we've got some video here of some people that have been in custody, in prison, and they know, and that's what this group is.
It has been revealed that the youngest of Diddy's victims could be, this is from an attorney in Houston, could be as young as 9, but plenty of them were minors. How does that change the dynamic within the prison system if it is true and Diddy's convicted of having his way with boys?
That's it. Spend the rest of your life inside the scene, because once you hit their yard, you on the list. You already on the list, but if you get out in their population.
I'm sorry. What's the Cardell? I'm sorry. What's the term that you used? You're going to spend the rest of the time in the what?
Segregation.
There's no way they can't move in the general population. And would he be at risk? Sure, he'd be at risk. There's so many people that have nothing to lose, right? They're going to be in jail the rest of their life. They've got nothing to. They want their 15 minutes of fame. They were friends with Diddy, or they hurt Diddy, or they killed Diddy, or they did. I mean, there's so many, people in jail that this would be their moment. You can't put them there.
Quote, Mr. Combs clearly intends to face and contest the charges, not flee. Nor do significant penalties and serious reputational harm demonstrate any risk of flight. The government has already destroyed Mr. Combs' reputation, and his only hope is to stand and fight, which he intends to do not only on this front, but also against dozens of civil lawsuits. As for possible penalties, none could compare to the prospect of abandoning his 7 children, his mother, and other family members, as well as the remarkable career he has built for himself.
Okay, so that's kind of my pitch. Go ahead and comment on this, because I think that this guy, if he's guilty, a death penalty would not necessarily be a bad thing. I mean, he doesn't offer anything to society except for he's a drain on the society's resources. And guess what? That's how they're going to feel about it in prison too. But it's in prison, it's about, so that's your crime, that's why you're here. So he's going to have a target on his back from day one. With that, now he's got a new problem, and that is, it appears that his lead counsel walked out of the courtroom. I haven't been able to confirm that he's withdrawn, but there's definitely something going on the defense team. I'm not sure. We'll follow up on that, but it is of concern for P. Diddy.
And now his attorney just up and walked out of the courtroom. Man, Diddy's world is crashing down hard. The lawsuits, they're coming at him like a tidal wave, piling up faster than anyone can count. And now he's stuck in jail with no bail, facing the kind of heat that even his money can't put out.
Well, everybody, I try to pick topics that illustrate some legal point here. So again, I think that if these allegations are true, he should spend the rest of his life in prison. However, on the other side of it, as defense counsel and me, there is this presumption of innocence that has to be overcome by the government. And until that has been completed with a jury and they have rendered a verdict, it doesn't seem to me to be consistent that he would be held as a person presumed innocent no matter what the allegations were, so long as he can be assured to return to court and the public is safe. And I believe that can be done without keeping him in custody, without hobbling his defense, because it almost works to the government's advantage. If you can keep them in custody and then also make their defense very difficult, wow, another little edge up for the government. Well, the government doesn't need any extra. Well, that's my 2 cents worth. Until the next time, this is Lieutenant Colonel Lee Roger Wolfgram from the Wolfgram Worldwide Headquarters, out here.